Now I am going to dictate a legal passage based on Kolkata High Court latest judgment at the rate of 160 words per minute. Let's start. MS Paul submits that the alleged accident happened on 02/07/2019 and the victim succumbed to his injuries on 03/07/2019. The FIR was filed on 05/07/2019. She submits that there was delay in a filing FIR and the delay was never explained properly by the claimants. She further submits that the offending vehicle was not at all involved in the alleged accident. She further submits that the inquest was conducted upon the dead body of the victim. From the said inquest report, it would be revealed that the victim was dashed by an unknown vehicle. Para. Mr. Mondol, learned advocate appearing on behalf of the claimant, submits that the ground for non-involvement of the offending vehicle was not properly proved by the insurance company. He further submits that the FIR was lost just after 2 days of the death of the victim. So it is quite reasonable that the de facto complainant, who is one of the brother of the deceased, must have engaged to the final rituals of the victim. He further directed that there is no evidence to substantiate the plea of the insurance company regarding the non-involvement of the offending vehicle. He further submits that the inquest report was not exhibited before the Ladi tribunal. Thus, there is no justification to entertain the ground. Para. It appears that the FIR was lost by one of the brothers of the deceased on 4th September 2019, though the police case was started on 5th September 2019. It further appears from the FIR that the de facto complainant was engaged due to the final rituals of his brother. Thus, he lost the FIR after 2 days of death of his brother. I find justification to doubt on that. It further appears that the inquest report was not placed on record before the Ladi tribunal, and the insurance company also not produced any specific evidence, either oral or documentary, to prove the non-involvement of the offending vehicle. However, considering the fact that the offending vehicle was seized by the police authority on 21/07/2019 and police has submitted charge sheet accusing driver of the offending vehicle, I find no justification regarding the argument of insurance company for non-involvement of the offending vehicle. Thus, the same point is turned down. Para. In considering the quantum of compensation as awarded by the Ladi tribunal, it appears to me that the Ladi tribunal has awarded a sum of rupees 19,60,000 as compensation of this case. In fixing the compensation, the Ladi tribunal has adopted a structured formula. The monthly income of the deceased was calculated rupees 10,000 per month. 40% future prospect was added with his income and 1/4 was deducted towards the personal expenses of the deceased. Para. MS Paul submits that the deduction of 1/4 towards the personal expenses, it is erroneous. In this particular case, the widow, minor son, mother and father of the deceased were made claimants. Father claimant number 4 within bracket father of the deceased was not dependent upon the income of the deceased. However, no evidences were produced by the claimants to prove that the father was dependent upon the income of the deceased. She argued that in this case, considering the observation of the apex court in Sarola Borba, the correct deduction would be 1/3 instead of 1/4. Para. Perused the claim application. In the claim application, the father of the deceased is placed as the claimant number 4. Father is not a legal heir of the deceased to get any compensation. However, there is no evidence on record to show that the old father was dependent upon the income of the deceased. Considering the same, I find justification in the submission advanced by the insurance company. Accordingly, in this case, deduction towards the personal living expenses of the deceased would be 1/3 instead of 1/4. Thus, this point is decided in favor of the insurance company. Para. MS Paul submits that the offending vehicle was covered under the policy of the insurance company. The policy is a private car liability 1 policy. She submits that the police seized several documents, including the general power of attorney issued by the owner of the offending vehicle in favor of one MD Firoz Momin. She pointed out that the vehicle was given in power of attorney to the transferee for the purpose of transport business. The policy of the insurance company has some limitations. The limitation clause has been specified wherein it has been stated that the policy does cover for the purpose other than air or reward. MS Paul further submits that the car was used for business purposes. Thus, the insurance company has no liability to pay compensation as the owner has willfully violated the terms of the policy. Para. Mr. Mr. Mondal submits that the argument advanced on behalf of the insurance company is not correct. The policy was issued correctly for the private purpose of the owner. Stop. Thank you.